Welcome you all to the Clat series lecture number 3 in the Law of Torts, which is sponsored by Sri Jender Rank Zone. I'm your mentor, Shekhar Galot. We are discussing Law of Torts, and in this class, we will be finished with our Law of Torts syllabus, which is a key component in the Clat scenario. So we had done defamation. Now we'll do the defenses to defamation. Suppose someone has alleged that you are guilty of committing defamation. How will you skid away your responsibility of committing a defamation, or what are the defenses which you can claim for committing a defamation for someone? Okay. Defamation, as we all have discussed, is lowering the a statement which has the impact of lowering the reputation of someone in the minds of the right thinking people of the society. Okay. So defenses to defamation. You give it a quick look and then we will discuss it. First one is the defense of truth. Okay. Often the most straightforward defense of defamation is to prove that the communication in question stated the truth. This will result in complete and absolute exoneration for the defendant, even if the defendant had malevolent intention when communicating the information. And regardless of whether it was in the public's interest to make it known, the veracity of claim will still provide our defense. Okay. Truth is the best defense. Okay. Truth is the best offense as well as best defense. Truth is the best offense as well as best defense. If you want to offend someone and you know some truth about that person, but that should be a proven truth, you state the truth open in the public. You level that allegation and that person will be destroyed. Plus, also it is a the best defense as well. If someone claims that you have defamed someone, you have insulted someone, you have brought down somebody's reputation in the public, then there is no best defense than the truth. See, defamation has a lot of defenses, but the best one is the truth, that what I spoke is just truth. In the previous case we discussed that I can call someone corrupt, but can when can I call someone corrupt? When the court comes to a conclusion that an officer is corrupt, I can call him corrupt. There will not be any defamation. Okay, there will not be any defamation at all, because court is the medium which finds the fault. If court has found fault in someone and I just reproduce that fault finding by court in public, that this person is found to be thief or found to be a corrupt person or found to be a bribe taker, then he cannot later on call me a person who has brought down his reputation, because this is truth. Okay, and I state the truth. Even if when I wanted to state truth, the intention in my mind was not for the public good. The mind intention in my mind was just to cause harm to that person. I had some enmity and wanted to cause personal injury or harm to that person. Then also if I have stated that fact, but if the fact is truth, then there is no defamation at all. Okay, no defamation at all, because it is a truth. Fair comment. Okay, a fair comment is just like of an a fair comment is just like as an honest opinion. Okay, fair comment is just like an honest opinion. Suppose I'm a person who writes in the magazines, who writes in the newspapers. I make a comment on someone or I criticize someone. Like, suppose I watched a match yesterday and I did not like the performance of some sports star. I make a comment that he could have been more well prepared, or he could have played well, or he could have not played that particular shot, or he could have not done that, or he could have not done that, and blah blah blah. Like today, Bihar elections results are out. So I can now say that RJD should have contested better in that seats. They should have fielded those candidates, and this candidate should have done that and this. These are just fair comments and honest opinions. They commute no harm to anyone. They are not intended to harm someone. It is just a fair comment. Like when I criticize demonetization, I say that demonetization was a bad move and Pradhan Mantri Narendra Modi should not have done that. It is not that I am trying to bring down his reputation. I am just trying to say that Modi lacked that foresight. Narendra Modi did not have that understanding of the demonetization or the running of the country when he brought the demonetization and the country suffered a loss. This kind of a comment, I read this comment in so many newspapers, so many articles, so many journals, so many videos. So all of those people who are saying this, and then I read comments which say that demonetization was the master stroke. This should have been brought by the Manmohan Singh. This should have been brought earlier. Okay, it could have been more beneficial. I read comments like this as well. Now, these comments do not mean any harm to even Narendra Modi or to Dr. Manmohan Singh. Okay, so these are honest opinions, fair comments. So, somehow, some intentional commenting after some fair comments, someone feels that he has suffered some injury. Then you can offer that it was a fair comment and it will be treated as a defense. Yes, but it will depend upon the nature of the statement made. You cannot simply make a insulting statement in the name of, in the garb of making a fair comment. By making a fair comment, you cannot ingress into someone's reputation. You cannot transgress boundaries and go on calling name and then say it was a fair comment. Okay, you have to be very reasonable. It can be used as a defense to defamation claims. If the defendant can show, defendant is someone against whom the case is made, that the statement made in question was an opinion, that I hold this particular opinion. It is just an opinion, not a statement of fact. You must understand statement of fact versus statement of opinion. I feel that this person is corrupt. This is not an opinion. This is a kind of statement of fact. Okay, but I feel that administration is not working in an efficient way. This is an opinion. The district collector is not functioning efficiently. This is an opinion. But district collector is a corrupt person. This is an accusation. This is not an opinion. Okay, so there is a very thin line of difference between a fair comment and a real libel. Okay, so you have to understand that thin line of differentiation and you have to work on those boundaries, that within the statement there was an apparent basis to opinion. Okay, that there was a base. When I made the statement, I also gave the rationale, I also gave the reason for making that statement. The statement is one that an honest person could have held, and the statement is such that any honest person or an honest opinion maker would usually hold. Okay, so it is kind of a general statement, so this can be a defense. Let's have it as first, let it be second, then publication on the matter of public interest. That the matter was a matter of public interest and it was a duty as a journalist or as an investigative person to bring it to the light of the public. It is a defense to defamation claim is if the defendant can show that their comments were made regarding a matter which is of public interest and that they reasonably believe that the publishing the matter was in public interest. Now, sometimes you see there are sting videos, sting operations. In those sting operations, usually journalists go and tap and record videos and audios of public officials taking bribes or talking about bribing, etc. Now, when they release them in public, usually they are not counted as defamation. They say that this is a kind of sting operation and it is a matter of public interest that the government should not function in a corrupt manner. So we are conducting a sting operation. Those sting operations still their validity is still very much doubtful. It depends on case to case basis. Okay, but publication on the matter of public interest is definitely not a defamation. Okay, like there was a controversy when this MP Tharoor, MP Shashi Tharoor, his wife Sunanda Pushkar got shares as gift. She got shares of substantial value as gift. Okay, so there was a controversy. So people published that she got shares because she is the wife of the minister and this and that. Okay, so there was no claim against the Tharoor by the publication houses because it was a matter of public interest. Okay, so when a matter of public interest is brought to the public, then usually this is a sufficient defense for the claim of defamation. Okay, but it has to be, again, every action has to be very reasonable. You cannot go on saying anything and everything that you want in the name of public interest. It has to be tested on the touchstone of the constitution, whether is the statement was really a matter of public interest or not. Okay, but anyhow, this is a defense. The other defense is absolute privilege. Absolute privilege allows for complete freedom of speech with no fear for being sued for defamation, and is applied to certain special situations no matter how malicious or false the information is. All proceedings in the parliament and court are afforded absolute privilege, as is the communication between a solicitor and a client, interstate communications, official communications between state officials, etc. These statements are absolute privilege. These statements are by the law protected from the law of defamation. So whatever happens in the parliament, okay. Okay, whenever there's a discussion happening in the parliament, and whatever a minister or whatever a member of parliament discusses, he says that Sachin Tendulkar is a corrupt person, then it is immune. Even if he said so in order to harm Sachin Tendulkar, then also he is immune from charge of defamation. Why is it so? Because parliamentarians or the state legislatures, they are the voice of people, and the voice of people should not be muzzled under the threat of law of defamation. If tomorrow everyone is allowed to file a defamation case against a parliamentarian or a legislature for making the statement in the legislature or the parliament with respect to the place, then tomorrow how the voice of people will be heard? Parliament is the voice of people, and we cannot curtail the voice of people. They are the representatives of people. Their voices can't be muzzled by the threat of defamation law. Otherwise, they will not be able to speak freely, and the people's issue will not be able to taken up freely. So tomorrow, if they make a statement that a collector in some particular area is a corrupt person, this collector cannot do anything. He cannot just file a case of defamation if the statement is made in parliament. But if the state is made outside the parliament, then he is not immune to that statement. Okay, or if the communication is made in the court, in the proceedings, if something is stated in the court, then that thing is privileged, that thing is protected. Or communication between a solicitor or a client, a lawyer and his client, whatever the client tells the lawyer that he has committed the murder, how he has committed the murder, tomorrow this lawyer cannot go and publish the statement or say or go to the court. There is an absolute privilege. Okay. Or interstate communications, when one state is communicating with the other state, when Tamil Nadu state is discussing the issues with the Delhi state, or there's an official communication between the state officials. Suppose the DGP of the Maharashtra is talking with the DGP of the Bihar, whatever language they use with each other, whatever they state to each other, whatever allegations they make against each other or any other person, is protected from the official communications, provided the communication has to be official. It cannot be an unofficial communication and then the person claim immunity just because he is an official. Being an official is no privilege. Okay, only an official communication is privilege. So these are absolute privileges. That means ultimately at all no question can be raised upon these statements. Now the fifth tort is tort of negligence. We are also doing simultaneously the kind of torts. The fifth tort is tort of negligence. In everyday usage, the word negligence denotes mere carelessness. Okay, when you are negligent, then you are careless. Okay, like we say that he is negligent about his studies, that means the person is not taking good care of his studies, he is not devoting enough time in his studies. Or a sports person is negligent about his health or his practice, that means he is careless. In legal sense, it signifies failure to exercise standard of care which the doer as a reasonable man should have exercised in the circumstances. When we talk about the negligence in the legal sense, we mean it is a duty which every person is supposed to observe, a reasonable standard of safety which every person in that particular situation is supposed to observe as per the law. Suppose I'm driving. I'm supposed not to be intoxicated. I'm supposed to be having a valid driving license. I'm supposed to be having a valid vehicle with all test certifications done. Okay. And I'm supposed to be driving on my road. I'm supposed to be driving within the speed limits. I'm supposed to be wearing a seat belt and so on. Okay. So these are the reasonable precautions which law presumes that every presumes not presumes but law binds everyone to follow on given occasion. Okay, so if I am negligent in my duties and a harm is committed to someone else, then the person will get a right to file a case of tort against me if, due to my negligent acts, someone is hurt. Okay. In general, there is a legal duty to take care when it is reasonably foreseeable that failure to do so was likely to cause injury. Negligence is a mode in which many kinds of harms may be caused by not taking such adequate precautions. Okay, not taking such adequate precautions. Like we discussed the case of a hotel in the beginning. Hotel did not place signs. That was a negligence on the part of hotel, and someone died and suffered injury. That is a tort of negligence. Okay, or I have a ferocious pet dog. I have a ferocious pet dog which is known to biting people unprovoked. Okay, which is known to biting people unprovoked. And I take the dog in the park where children are playing and I leave the dog open. And it bites people, it bites kids as well. Kids as well, it injures people. Then I am negligent in my duties in holding my dog. Okay, so that means I am negligent there. So if my dog bites anyone due to my negligence, definitely the person can file a case against me. Or I am driving without license. I am driving without license. I cause injury to someone. Okay, I cause damage to somebody's vehicle or somebody's life or somebody's limb. Then definitely I am driving negligently. This is a crime as well as a civil wrong. The other person can definitely file a claim of compensation in the nature of torts against me in the court of law. Now, what are the defenses for the tort of negligence? Okay, in action for negligence, following defenses are available. Contributory negligence. It was a common law rule that anyone who by his own negligence contributed to the injury of which he complains cannot maintain an action against another in respect of it, because he will be considered in law to be author of his wrong. Contributory negligence is the contributory negligence is a defense. What is contributory negligence? When two people then no one is liable. One is driving without a helmet, other is driving on a one is driving without a helmet, other is driving without on a wrong road, other is driving on a wrong side of the road, other is driving in the intoxication, in the influence of alcohol. One has taken alcohol while driving, other is driving on the wrong side of the road without headlights. So now there is a collision. Who will blame whom? No one can blame anyone. They both will have to suffer their own damages. Okay, because it's a case of contributory negligence. It's a case of both have contributed to each other's negligence. Okay, so when two people commit negligence, both of them are negligent, careless, and something wrong happens, then no one is to be held liable for that. Act of God or which nature. It is such a direct, violent, or sudden and irresistible act of the nature as could not by any amount of human foresight have been foreseen, or if foreseen, could not be by any amount of human care and skill have been resisted, such as storm, extraordinary fall of rain, extraordinary high tide, earthquake, etc. Okay, no matter however precaution you may have taken, but an act of God is an act of God. Okay, so your negligence will be brushed aside in the act of God if the act of God is so heavy that even if you have taken care, then also you could not have stopped something from happening, from an accident from happening. Okay, like you are controlling a dam's chief engineer You are dam's chief engineer and the water level is so high. Water level. Okay. Water level is high already and it is raining for almost 3 to 4 days without any stop and it's raining heavily. Definitely your dam is going to overflow and some areas are going to be submerged. Some people will have to suffer. There is going to be flood. A lot of agricultural land is going to be wasted. But now chief engineer cannot be found fault with the dam because this is an act of God. Okay, this is an act of God. So such is an act of God or state is negligent in maintaining a road, suppose. But the earthquake was so intense that even if maintained properly, the road would have caved in. So now the road have caved in. You cannot find fault with the state because definitely it is an act of God. And even if all precautions had been taken by the state, then also the road could not have been prevented from submerging or from, sorry, not submerging, but from caving in or from going under the ground. Okay, so this is an act of God. This is a perfect defense to the tort of negligence. Inevitable accident. Inevitable accident also works as a defense of negligence. An inevitable accident is that which could not possibly be prevented by the exercise of ordinary care, caution, and skill. It means accident physically unavoidable. Okay, an accident which is physically unavoidable, no one can be found fault with that. Okay, no one can be found fault with that. Some are inevitable accidents, like few days ago I saw a TV video in which a car in Hyderabad was being driven so carelessly by someone that it jumped over the bridge and fell over the car below. Okay, it fell over the car below, and the car below there was a big traffic there was a big traffic accident due to that fall. So that fall was inevitable. They could not The people who were driving on the road below could not have anticipated that such a car would come flying and land in the mid of the road, and suddenly all people applied emergency brakes. Some could apply it, some could not apply it, and there was a massive accident. So definitely they can find fault with the one who has come down crashing with his car negligently, but other people cannot be blamed for it. Okay, other people cannot be blamed for it. Or there is a thick fog due to which some accident happened, so you can say that it's an inevitable accident. But anyhow, it is very difficult to find inevitable accidents in the law. Okay, every accident has some responsibility, but if you can somehow show that the accident was inevitable one. Suppose you are a doctor trying to save life, but despite all effort, despite your all efforts, the patient has died. That is inevitable. That is an inevitable accident. You could not control such an inevitable accident. Okay, so these are the defenses to the tort of negligence, that it was so inevitable that nobody could have stopped it from happening. Now the other tort is nuisance. The word nuisance is derived from the French word nuire, which means to do hurt or to annoy. Nuisance is usually to hurt someone or to annoy someone. Okay. One in possession of a property is entitled as per law to undisturbed enjoyment of it. Okay. So if I have a property, I am allowed I am I have a legal right to enjoy this property without any disturbance by someone. If someone else's improper use in his property results into an unlawful interference with his use of enjoyment or enjoyment of that property or some right over or in connection with it, we may say that tort of nuisance occurred. In other words, tort nuisance is an unlawful interference with a person's use of enjoyment of land or some right over it in connection with it. Nuisance is an injury to the right of a person in possession of a property to undisturbed enjoyment of it and result from an improper use of another person's property. Okay, somehow this may be quite confusing to you, but let me make it clear very much. Not everyone has a right to peaceful enjoyment. Okay, my neighbor in the night plays heavy, loud music. What he is doing in his own premises, okay, but his sound is entering into my house. So my due to this, my sleep is affected, or my kids are studying, their studies are affected. He cannot play such a loud music even if he is playing it in on place. That is a nuisance. Okay, or there is a car workshop near my house. There's a car workshop near my house, and they are all the time creating a lot of noise of machinery, beating the cars, and this and that. This is a nuisance. Or there is a flour mill near my house. It is creating unnecessary fumes and vibrations in my house. A nuisance is committed. Or my neighbor runs a dairy business and has cattle. Now the cow dung smell is in my house and unbearable. This is nuisance. This is nuisance. Okay. So you can find nuisance in different ways. Okay, this is the anything which is preventing you from lawful enjoyment and peaceful enjoyment of your own property, it will become nuisance to you. So these are some examples of the nuisance. Now I hope you understand what we are talking about here, what nuisance is. So okay, so this is a tort of nuisance. If someone is guilty of committing this, the other person can definitely reach to the court and seek an injunction or the compensation for that. Injunction means seek a prohibition on that activity, that you should not play loud music, or you should not keep cows here in the area, or you should cover your flour mill, or you should dispose of your cow dungs properly, and this and that. Okay, throwing the garbage in public, this is also a nuisance. Or neighbor's dog keeps barking all time. Neighbor's dog keeps barking all time, that is also a nuisance. Okay, now, distinction between a nuisance and the trespass. Trespass is direct physical interference with the plaintiff's possession of land through some material or tangible object, while nuisance is an injury to some right accessory to possession but no possession itself. Okay, so trespass is definitely, what is trespass is the injury to my right to possession. Now I am living in my property, someone else physically comes in. Now he is also staying there. Why should he stay in my property? He has physically come into my property, or he has physically put some ladder into my area, or he has planted a tree in his garden which is now accessing into my balcony. Why someone should do that? That is a physical trespass. But when he is you playing loud music, or when he is having cattle dung, then the smell or the music is coming to my house. Though there is no physically nobody is entering into my possession. My possession is secure. Nobody is threatening to remove me from my land or unnecessarily entering my land, but definitely the dust fumes, the smell, or the loud music is entering into my house, and my peaceful possession is being disturbed. Okay, Trespass is actionable per se, while nuisance is actionable only on proof of actual. Trespass is actionable per se. Someone enters into my property without my permission. The moment he enters, he is guilty of trespass. But nuisance per se is not per se. Per se means just because it happens. Nuisance per se is not objectionable. So if someone is playing a loud music, doesn't mean that I'll file a case against him. There may be some occasion, but it is not that he will play every day. But if occasionally he has played it because there is some occasion in his family, there's a wedding or something else, then I cannot definitely file a claim. Okay, nuisance is reasonable. Okay, what are the essentials of nuisance? In order that nuisance is actionable tort, it is essential that there should exist wrongful acts. Okay, for nuisance to be a tort, there should be a wrongful act. Okay, and damage or loss or inconvenience or annoyance caused to another. Okay, in nuisance, there should be some injury to my legal right. Okay, in every tort there has to be legal injury, but in nuisance you have to somehow show damage as well. Not only legal injury will be sufficient, you have to show some damage as well. Inconvenience or discomfort to be considered must be more than mere delicacy or fastidious, and more than producing sensitive personal discomfort or annoyance. Such annoyance or discomfort or inconvenience must be such with the law which the law considers as substantial or material. Just because someone has played a loud music for half an hour, I cannot just go grumbling against that person. Okay, I cannot be extra sensitive. Okay, because someone is praying in his house and he is whistling or he is ringing the bell, that I'll file a case. No, you cannot be that extra sensitive. But yes, if someone is playing loud music incessantly day night, then definitely it becomes a nuisance. But sometimes on one or two occasions it does not become a nuisance. You cannot be very much extra sensitive. It depends on the case to case basis, which thing which law assumes to be a nuisance. Okay, a reasonable man assumes to be a nuisance. We all understand that something may be a nuisance or something may be personally a nuisance. So whatever is personally a nuisance will definitely not be a nuisance. But if considered on a broad parameter, if this thing is nuisance, then that is a tort. What are the kinds of nuisance? Nuisance is of two kinds: public nuisance and a private nuisance. Okay, simply speaking, public nuisance is an act of affecting the public at large or some considerable portion of it, and it must interfere with the rights which members of the community might otherwise enjoy. Thus, acts which seriously interfere with the health, safety, comfort, or convenience of the public generally, or which tend to degrade the public morals, have always been considered public nuisance. Broad examples of public nuisance are pollution, throwing waste in river, damaging the road, blocking the road, okay, or cutting access to public road, noise pollution, sound pollution, water pollution, air pollution, all these kinds of pollution. Okay, or the corporation has dug up a road, but now they are not refilling it, so that is a nuisance. Okay, or someone has blocked a road, okay, which is a public road. He has unnecessarily put a gate there. Then this is not a proper way. Okay, so in these ways, nuisance will be a public nuisance which affects community at large, a lot of people at large. Okay, but it is important that one who files a case should be a part of that community. Okay, suppose there is some disturbance to a community in Tamil Nadu. I from Delhi cannot come and file a case for them. I have no locus standi. Only the people who live in Tamil Nadu who are suffering that nuisance, they have a right to file a case. Similarly, if there is some nuisance in Delhi, people from Gujarat cannot come and file a case here. Okay, only someone from Delhi who is finding that inconvenience due to that public nuisance can file a case. This is the public nuisance. Private nuisance is an unlawful interference and or annoyance which causes damage to an occupier or the owner of the land in respect of his enjoyment of private nuisance, like we discussed, playing loud music or creating dust fumes or creating floor mill fumes and etc vibrations etc. Okay, or honking. Now, what are the defenses to nuisance? First defense is prescription. Prescription means a title acquired by use and time and allowed by the law. Okay, something you are doing so many ages, so many ancestors have been doing it, so many generations have been doing it, and it has been allowed by law. Now it may be a nuisance for someone, but it will not become a nuisance, it will be a defense to the nuisance. A special defense available in the case of nuisance is prescription. If it has been peacefully and openly enjoyed as an easement and as a right without interruption and for 20 years, after a nuisance has been continuously in existence for 20 years, right to continue it is acquired as an easement appertinent to the land on which it exists. On the expiration of this period, the nuisance becomes legalized ab initio, as if it had been authorized in its commencement by grant from the owner of the servant land. The time runs not from the day when the course of nuisance began, but from the day when the nuisance began. Okay, so I'll explain you in a better way. I have a well in my field. It is my private well. Members of village also carry water from the well. They have been doing it from last 30 years, say. Now suddenly I cannot block the access to well, because now they have done it in such a manner that it becomes the right of the village to carry well from the water from my well. Now the well has become a kind of public well, it is no longer a private well. So now I cannot call all of these people as nuisance creators, because I have allowed them to take the well for 30 water from the well for 30 years. I should not have allowed them, but if I allowed, now it has become a tradition. Or I have a private temple, but people of village use it to worship from 40 years. Now I cannot call it a private temple anymore. Okay, now I cannot stop the people because they have used it as a place of worship for 40 50 years. I should have stopped them. Okay, and I cannot say that I was not aware of this law, that if they use it for 20 years it will become a public well or public temple, because we have done in the maximum ignorance of law is no excuse. If you are ignorant about the law, it is at your own risk. If you are ignorant, now the property must go to the public. Okay, that is the crux of prescription. Statutory authority. Where a statute has authorized the doing of a particular act or the use of land in a particular way, all remedies, whether by way of indictment or action, are taken away, provided that every reasonable precaution consistent with the exercise of statutory powers has been taken. Statutory authority may either be absolute or conditional. Okay. Now there is a in Tamil Nadu we have a nuclear plant. I do not know the exact name of the place. I forgot it. It's something from K, something like this. Okay. So I know that Tamil Nadu state has a nuclear plant set up by the government of India. Now this nuclear plant is set up by the statutory authority. Now the people of Tamil Nadu and the nearby people definitely will have issues with the nuclear plant. Everyone is afraid of the nuclear energy and nobody wants the nuclear energy to come to nearby them, near their families or near their children. Okay. But they have it there, and because of the statutory authority we cannot claim that this is a tort. Okay, because they have a nuclear plant. Or similarly we have mobile towers. We have mobile towers, electricity towers in the locality. Everyone feels that there are a lot of radiation and they are causing cancer and so on. Okay, but they are constructed under the law, authority of the law, so we cannot say that they are doing some nuisance, provided provided they adopt reasonable precautions. Like when the setting up of nuclear plant, government must have created a buffer zone, must have relocated so many villages, must have left a lot of areas, a vacant area around the nuclear plant. Okay, or when constructing a dam, government takes a lot of villages and get them vacated so as to create any threat to someone. So they are creating a dam. It is being created in the under a statutory authority. Okay, it's a statutory authority. So tomorrow you cannot claim that because of this dam I have lost my right to peaceful enjoyment and this and that. Okay. So statutory authority is a defense. In the claim of nuisance, following are no defense that shall be used. These are not the defense, okay, but now these are the defenses. What are not defenses? No defenses. Plaintiff came to the nuisance. If a man knowingly purchases an estate in close proximity to a smelting works is remedy, for a nuisance created by fumes issuing therefrom is not affected. It is not valid defense to say that the plaintiff came to the nuisance. Suppose I am doing some illegal activity in this area which is not allowed, like a smelting work. Okay, and somebody has purchased a land near me. I cannot say that I was doing this previously to he came. Now when he has come here, he has himself came to the nuisance. Why he has purchased a house here? He should have purchased house somewhere. I will keep on continuing my activity. No, if you are committing nuisance, if plaintiff came to the nuisance or you went to the plaintiff, it hardly makes a difference. If you are committing a nuisance, then plaintiff came to the nuisance is not defense. You are running a dairy, I purchased a house, there's a lot of smell, I file a complaint, then it's a valid complaint. You cannot say that I have been running this dairy for 50 years, he came tomorrow only, he came yesterday only. Okay. In case of continuing nuisance, it is no defense that all possible care and skill are being used to prevent the operation complained of from amounting to nuisance. In action for nuisance, it is no answer to say that the defendant has done everything in his power to prevent its existence. Okay, now someone is running a dairy. He cannot say that I have tried all the best so that the smell does not go to his house, but still smell is going. What can I do? This is not a valid defense of a nuisance. Or if someone is playing a loud music, he says that I have played all the loud music and I have the soundproof house, all the things in place, still the sound is going to his house. What do I do? This is not a defense. If nuisance is happening, you have to stop it either way. Either you control it or you remove it. That's it. It is no defense that defendant's operations would not alone mount to nuisance. Okay, he cannot say that it's not only me, but everyone else is doing this. Okay, the other factors contribute to the smoke complaint of. Now I file a case against a factory in my area which is contributing a lot of smoke pollution. He goes and say there are a lot of factories in the country whole are contributing to smoke. Why you are holding me personally liable? This cannot be a this cannot be a defense for the nuisance. Okay. It is no defense that the defendant is merely making a reasonable use of his own property. No use of property is reasonable, which causes substantial discomfort to others. Okay. Similarly, if you are playing loud music, you cannot say that this is my property. I do whatever I want to do with it. Okay, I enjoy my property. You cannot do that. You have to make the reasonable use of it. Okay. If your reasonable use is threatening somebody else's peaceful possession, then you cannot take it as a excuse that the nuisance complained of, although causes damage to the plaintiff as an individual, confers a benefit on the public at large. A nuisance may be inevitable result of some or other operation that is of undoubted public benefit, but it is an actionable nuisance nonetheless. No consideration of public utility should deprive an individual of his legal right without compensation, like you are having a temple. I am having a temple or a mosque in my area, they are playing loud music all the time, or loud prayers are there on the loudspeakers, and they say a lot of community, Hindu or Muslim community, is being benefited from our prayers or loudspeakers, and only this person is having an issue. No, this cannot be said. If nuisance is there, then there is no defense to the nuisance. That the place from where the nuisance proceeds is the only place suitable for carrying on the operation complained of. If no place can be found where such a business will not cause a nuisance, then it cannot be carried out at all, except with the consent or acquiescence of the adjoining proprietors under statutory sanctions. You cannot say that this is the only place where we can do this particular thing which is causing nuisance. Okay, you have to find a
It's
suitable
six
place.
o'clock.
If you cannot find a suitable place at all, you have to shut down the place. That's it. Or you take the consent. So these are the things which are, these are defenses which are not available, okay, against a claim of nuisance. Now the other one is, another tort is tort of malicious prosecution. Malicious prosecution is the malicious institution of unsuccessful criminal or bankruptcy or liquidation proceedings against another without reasonable or probable cause. This tort balances competing principles, namely freedom that every person should have in bringing criminals to justice and the need for restraining false accusations against innocent persons. Malicious prosecution is an abuse of the process of the court by wrongfully setting the law in motion on a criminal charge. The foundation lies in the triangular abuse of the court process of the court by wrongfully setting the law in motion, and it is designed to encourage the perversion of the machinery of justice for a proper cause. The tort of malicious prosecution provides redress for those who are prosecuted without cause and with malice. In order to succeed, the plaintiff must prove that there was a prosecution without reasonable and just cause initiated by malice and the case was resolved in the plaintiff's favor. It is necessary to prove that damage was suffered as a result of the prosecution. Okay, so whatever is written here, it simply means, I'll just simplify it for you. You can read it. Whatever is written is right, but because somehow it is confusing, so I'll clarify it for you. Malicious, malicious. We did legal maxim. We read bona is good, mal is bad. So malicious means bad, fraudulent. Fraudulent or bad case. Okay, if someone has filed a fraudulent or bad case against someone, I file a false case against someone. I know that I'm filing a false case, but I just file a case because I have enmity. I want to trouble that person in order to harass that person. Fraudulent bad case for harassing someone. Okay, filing a false charges against someone, filing a false complaint with the police or with the court. This is a malicious prosecution. Okay, now malicious prosecution is not one where someone is discharged or acquitted or left free by the court, but it is one which is instituted with falsehood in mind. Okay, see, so many cases go to the court, and in many of the cases, people are left by the court. Court do not find the sufficient evidence. It does not mean that every case will become malicious prosecution or false prosecution. Only those cases which are based on the falsehood. When the person alleged that case, initiated that case, the person knew that this case is false and I am going to level false allegations. When you can prove that since beginning this case was false, then only the case will be called a malicious prosecution, not otherwise. Okay, if I file a case against someone and the case is dismissed, it will not automatically become a malicious prosecution. Okay, the court must observe that when I filed the case, it was a false case. Okay, this is malicious prosecution. This is also a tort. Now, in malicious prosecution, what a person is supposed to prove? The one who files a complaint that I have been prosecuted maliciously, he has to prove that he was prosecuted by the defendant. There must have been a prosecution initiated by the defendant. The word prosecution means proceeding in the court of law charging a person with crime. To prosecute is to set the law in motion, and the law is set in motion only by an appeal to some person clothed with power, like police or court. The person to be sued is the person who was actively instrumental in putting the law in force. Okay, that means prosecution is always a criminal trial. That means someone filed a criminal trial against you, someone instituted a criminal trial against you maliciously, falsely, and now you are filing a case against this person who is instrumental in setting up a false case against you. It may be a police officer, it may be a complainant, or it may be a advocate, it may be anyone. Whoever is instrumental in setting up a false case against you, he is guilty of committing a false prosecution. The proceedings complaint was terminated in favor of the present plaintiff. Present plaintiff means now you are plaintiff, now you are the complainant of the malicious complaint prosecution. Those proceedings which were initiated by you, okay, against the false person must have terminated in your favor. You should have been discharged or you should have been acquitted. Okay, the plaintiff must prove that the prosecution ended in his favor. He has no right to sue before it is terminated and while it is pending. When it is pending, you cannot file a case. Only after termination of proceedings, and when the proceedings have terminated in your favor, when the court has observed that he has committed no harm at all, this case is false, this case is absolutely fake case, then only, okay, then and then only you can file this case. The termination may be by an acquittal on the merits and finding of his innocence, or by a dismissal of the complaint for technical defense or for non-prosecution. If, however, his is convicted, he has no legal right to sue and will not be allowed to show that he was innocent and wrongly convicted. But if you are convicted, you cannot file a malicious prosecution at all. That the prosecution was instituted against without any just or reasonable cause. You have to show this as well, okay, that there was no reasonable cause against you. It was totally false case. Just because you are acquitted does not mean that you will go and file a malicious prosecution against the complainant or the police officer or the advocate. No, you have to show with the proof that what he said was false and he knew it was false right from the beginning. He knew it was false. Okay, it is very difficult to prove. So usually we do not see a lot of prosecutions in the name of malicious prosecution. We do not see cases which has malicious prosecutions. Okay, malice. Malice means bad intention, falsehood. That the prosecution was instituted with the malicious intention, that is, not with the mere intention of getting the law into effect, but with an intention which was wrongful in fact. Malice for the purpose of malicious prosecution means having any other motive apart from that of bringing an offender to justice. Spite and ill will are sufficient but not necessary conditions of malice. Malice means the presence of some other and improper motive, that is to say, the legal process in question for some other than its legally appointed and approved purpose. Anger and revenge may be proper motives if channeled into the criminal justice system. Okay, first, so basically, what this is saying is that you have to show the malice. Malice means you have to show that there was a bad intention. It is not that merely somebody made a complaint against you, okay, that you will file a case against him for the malicious prosecution. No, you should show that this person filed a false case. Okay, merely filing a case against someone is not a malicious prosecution. I am again repeating on the record, merely filing a case, and even if you are acquitted, even on merits you are acquitted. Okay, acquitted means you are set free by the court, you are not found guilty. Then also you do not get a right to file a malicious prosecution against someone, only and only when you are able to show that this person filed the case with falsehood in the mind. He was stating lie all the time. He has framed me. Then only it will be a malicious prosecution, and it is very difficult to prove that someone framed you. So that is why we see very less number cases of malicious prosecutions here. That he suffered damage to his reputation or to the safety of person or to the security of property, that you suffered some damage because of this malicious prosecution. Definitely prosecution itself amounts to suffering of damage. You do not need to show further damage. Prosecution is sufficient. It has to be proved that plaintiff has suffered damages as a result of the prosecution complained of. Even though the proceedings terminate in the favor of plaintiff, he may suffer damage as a result of prosecution. Yeah, definitely, the prosecution itself alone is tantamount to a lot of damage to your reputation as well as to your peace of mind. Okay, so but again, I'm making it clear malicious prosecution is very difficult to prove. That's it. Then we now proceed to the topic F, which is the last leg of the law of tort, which talks about strict and absolute liability. Okay, you read it meanwhile, and I'll catch up with you people in a moment. Now we are on the last leg of the law of tort. That is the last topic, that is topic F, which talks about strict and absolute liability. What is a strict and absolute liability? We will discuss in this particular chapter. This rule of strict liability was laid down in the famous case of Ray Lenz versus Fletcher. Okay, this Ray Lenz versus Fletcher is a 1868 case which was decided by House of Lords. House of Lords is the highest appellate body of the United Kingdom, or you can say it is just like what we have a Supreme Court here. House of Lords is simply the Supreme Court of United Kingdom or the Britain. Okay. So what happened in this case? The defendant mill owner employed some independent contractors to build a reservoir. Reservoir means water reservoir. That time, because nowadays water is easily accessible. That time water was not that easily accessible. You had to store it. There were no taps and so on. Okay, so he built a reservoir with the independent contractors. Beneath this reservoir, there were some iron shafts that went through a mining area and which were connected to plaintiff's mine. There were some mining shafts beneath this reservoir and they connected to the plaintiff's mine. Okay. Defendant was not aware of these shafts. He did not know these shafts because definitely he is not constructing a reservoir. Reservoir is being constructed by the contractor, so a person cannot know that there are shafts. Contractor were negligent in not blocking the shafts. Contractors did not block the shaft. They should have blocked the shafts, but they did not block it. The plaintiff's mine was flooded when the reservoir was filled with the water. When he filled the water in the reservoir, the water escaped to the mine and his mine was flooded and it caused a severe damage to his mine and his property and he filed a case. The defendant said that we were not negligent and we are not even vicariously liable for the acts of independent contractors like we discussed. But the House of Lords, actually, is how the House of Lords held them liable to the plaintiff. House of Lords still held them liable. What Justice Blackburn, said in his decision, we think that the true rule of law is that the person who for their own purpose brings on his land and collects and keeps there anything likely to do mischief if it escapes must keep it at his peril, and if it does not do so, is prima facie answerable for all the damage which is natural consequence of its escape. So, if you bring something which is unnatural to your land and it escapes, then you are liable for that damage, even if it was not your fault. This statement is also known as the Rayland versus Fletcher rule in Rayland versus Fletcher, or the rule of strict liability. So, if you bring water which is not naturally should be there and you make an unnatural use of land, and if the water escapes and floods someone else, you are liable even if you are not negligent. Okay, similarly, if I bring a python, okay, if I it eats the neighbor's calf, neighbor is having a animal husbandry, his calf is eaten by the python, then I am liable for it. Okay, though I may not be negligent, but somehow python escaped. Okay, or if I keep acid and acid fumes escape and cause damage, I am liable. Okay, because acid is dangerous if it runs away, and acid is not a natural use of land. This statement is also known as the rule laid down in the Rayleigh versus Fletcher. Now, what are the elements of strict liability? Dangerous things or things likely to cause damage if it escapes. First thing is that you have to keep there must be a dangerous thing on someone's land. There must exist a dangerous thing. And the word dangerous has its own meaning under the dot. What is dangerous is a question of fact. The rule applies to anything which may cause damage if it escapes, like a python, like an acid, like a water, even electricity can be dangerous. Once this element is fulfilled, then the thing is dangerous thing. If I keep electric generator at my house and the electric shock is given to someone else, then that is a dangerous thing. The object or thing, therefore, need not to be dangerous per se. My object may not be dangerous. I brought it for some other purpose, but it ran away. Okay. Because there are objects which are safe if properly kept, but are dangerous if they escape. This principle successfully applies to gas, noxious fumes, explosives, fire, electricity, water, and sewage. Due to the difficulty and confusion that may arise between dangerous and non dangerous thing, a less confusing phrase would be things likely to cause damage if it escapes. Okay, so anything which will cause damage if it escapes, definitely will figure as a dangerous thing. Intentional storage or accumulation. This rule applies to an object, thing, which the D deems defendant purposely keeps and collects. Defendant will only be liable if he has accumulated the thing. Even if he himself has not accumulated a thing, he may still be liable if he has authorized the accumulation. Even if he did not do it but allows his relative to do it at his land, then also he is liable. The liability rests in those who have control over the thing. The rule is not applicable to anything that is naturally on the land. If something is naturally on the land, if I grow a tree and tree falls, that is not a dangerous thing. Okay. Escape. P is plaintiff. Plaintiff or complainant. Plaintiff is the legal word for complainant. Plaintiff must prove that there has been an escape. Escape means that thing has escaped from the place over which the D has no control and the authority to place over which the D has no control and authority. Okay. It escaped from place where D has control and authority to a place where D has no control and authority. It is not necessary that defendant has a proprietary interest in the land, okay, from where the escape occurs. That means even if you have taken the land on rent, you may not be the owner of the land. You may be the tenant of the land. Even if as a tenant you keep something which is dangerous if escapes, and if it escapes, you are liable. You may say that I am not the owner, but you are the user. You have the control. Key is the control. Okay, key is the control and authority, not the ownership. Okay, so don't confuse ownership with the authority and control. A tenant may have a control authority over the land which he has taken on rent. Okay, non-natural use of land. It must be some special use bringing with it increased danger to others and must not merely be ordinary use of land, such as use is proper for general benefit for the community. Okay, it must not be a natural use of land. Natural, like you are keeping some animals, like pet dog is there, a normal pet dog is there, or some cows are there for milking. They are not unnatural, but definitely electricity, water, acid, gas, fumes, chemicals, etc. They are non-natural to the land. Remoteness, possibility of damage. A defendant will not be liable for all consequential damages that result from an escape. Type of damage must be foreseeable. Okay, he cannot be made liable for everything. Only for those liable which is only for that damage which is foreseeable. Okay, if something else happens, he is not liable for that. Consent. What are the defenses available? Defense is available against the tort of strict liability. Again, the defense is consent of plenty, voluntary non-fit injuria. If your neighbor allowed it, and tomorrow if it escapes and damages neighbor, definitely no tort. Default of the plaintiff. Okay, now you are having a chemical in your land. Now plaintiff trespasses in your land and he is playing with the chemical unnecessarily without the authority and he gets damaged, his eyes are damaged by the chemical, then you are at not your fault. He is at his own fault, okay? Because he is coming in your property and using it abnormally. That is default of plaintiff. Act of God, some earthquake is there due to which the thing escaped. What can you do? Okay, this is a valid defense. Act of a stranger. Escape is caused by the deliberate act of a stranger which could reasonably have been anticipated by the defendant. However, mere negligent act of a stranger are not within the ambit of the defense. The act must be mischievous, deliberate, and conscious. Stranger includes a trespasser. Okay, some thief entered into my place. Okay, he was trying to rob my place, so he took some chemicals also with him. But while he was jumping my wall, he dropped some chemicals into the plaintiff's area, and the plaintiff suffered damages. I am not responsible. This is because of the stranger. Okay. Statutory authority. This is for the public authorities like a nuclear plant in Ernakulam, nuclear plant in Ernakulam. Okay. And oil companies, and it is acquisition of the construction of the statute in question as to whether or to what extent liability under the rule has been excluded. Okay. If something is done under the statute, like you are constructing a dam or you are building a thermal electric plant, government builds it. Adani, Ambani, Tata, they all are doing it. Electric plants they are having. Okay, and people are having gas chemical plants as well under the authority of the law. Or there's a Ernakulam nuclear plant. These are all under the statutory authority, so you can definitely not file a case against these things. Now in India we follow a case of absolute liability. In India, this strict liability is followed in the UK. In India, we follow absolute liability. Strict liability rule allows defenses or exceptions. What are the defenses? These are the defenses to strict liability rule. But absolute liability rule, which we follow in India, does not allow any defense at all. If something is done and some harm is caused, even if it may be an act of stranger or an act of God, default of plaintiff, statutory authority, or consent of the plaintiff, whatever may be the reason, if some damage is caused, you are liable. That's it. In India, we follow absolute liability. If you are doing something unnatural with the land and the thing is dangerous and it escapes, whatever way it escapes, you are liable. That's it. This is the rule of the India. Okay, we follow a rule of absolute liability. The rule came out after the Bhopal gas tragedy. Gas tragedy, also known as Union Carbide case. In 1985, a Union Carbide plant leaked some gases and thousands of people died and become deformed. From there, we got this absolute liability. In India, absolute liability is the standard of the tort liability, which stipulates that where an enterprise is engaged in hazardous or inherently dangerous activity, and harm results to anyone on account of an accident in the operation of such hazardous or inherently dangerous activity resulting, for example, in escape of toxic gas, the enterprise is strictly and absolutely liable to compensate all those who are affected by the accident, and such liability is not subject to any of the exceptions which operate vis-a-vis the tortious liability of the strict liability under the rule of Raylan and Fletcher. Okay, so in our India, we follow absolute liability. Enterprises is bound to compensate people, and we do not allow any exceptions. Those allowed by the rule of strict liability, as propounded in the case of Raylan versus Fletcher. In other words, absolute liability is the strict liability without any exception. That's it. This liability standards has been laid down by the Supreme Court in MC Mehta versus Union of India. These exceptions include plaintiff's own mistake, plaintiff's consent, natural disasters, third party mistakes, part of statutory duty. These are not defenses. These exceptions are part of these exceptions are here only mentioned. Okay, but they are not part of absolute liability. You cannot take them as exception, not allowed in absolute liability scenario which exists in India. Okay, The Indian judiciary tried to make a strong effort following the Bhopal gas tragedy December 1984 Union Carbide Company vs. Union of India case to enforce greater amount of protection to the public. The doctrine of absolute liability was therefore evolved in the oleum gas leak case. This is the oleum gas leak case and can be said to be a strong legal tool against the rogue operations that were negligent towards health risk of the public. Okay, so now this is end of our law of torts series.